All right, everyone. Thank you for joining us today to Get Closed, Get Paid. This is our first class of 2024. As you know, if you've attended our classes, Get Closed, Get Paid offers quality education for real estate agents and brokers on a variety of topics, from licensing and advertising to contract execution through closing. Kristen offers the perspective of Brokers Council, and I share my experience as a closing attorney. So now, let's get closed, get paid. Now, if you have any questions, you're welcome to enter the questions into the chat field. If you don't want to be recorded, then you may want to hold off on your questions till we get to the end. And I'll let Kristen take it away. Our first topic this year is Florida advertising rules. You can see our next class coming up is February 13th. Again, our Zoom classes are held at 10 a.m. on the second Tuesday of the month, and they will be posted on our YouTube channel. I'll put all that information in to the chat as well. And we do have a little bit of housekeeping. Kristen, want to go to the next slide? Because we have to give disclaimers because we are attorneys and that's what we do. This presentation, of course, doesn't create an attorney-client relationship between the attendee and our law firms. You shouldn't act or refrain from acting based on anything we say in our presentations. If you want specific legal advice, please feel free to contact us. And of course, our opinions are not necessarily the opinions or reflective of the committees on which we serve. We do serve on a number of committees through Florida Realtors and Florida Bar, local bars, local boards, and of course, these are our opinions. Our goal is to provide educational content for real estate agents. And the antitrust statement. These classes are, of course, a forum for the sharing of ideas, not to foster anti-competitive behaviors. So please be mindful when we're discussing compensation and commission. And with all of that said, Kristen, let's talk about real estate agent advertising.
All right. So just to give you guys a little bit of a preview of what's coming up next month. Next month, we have a guest speaker coming in from a branding consulting firm that specializes in branding real estate agents. But before we did that, we thought we should do a little class on actual advertising rules. That way we kind of set the stage of what advertising rules are applicable to brokers and agents in Florida. And then we'll let her come in and have a non-legal class that might be fun for everyone. Obviously, we spend most of our time teaching about some nuanced legal topics. So we thought a little break an application actually to help you build some business might be helpful for the beginning of 2024. So today we're going to go through FREC advertising basics, and then we're going to go through a little bit of the rules around deceptive and misleading advertising, social media rules, team rules, and then we'll open it up for discussion. All right. Hold on one second. I'm just going to minimize. Okay, so getting into the basics. FREC has a lot of rules that are specifically outlined. There's Chapter 475, and then there's a host of other rules that were brought out that interpret Chapter 475, and it's related to how real estate licensees can advertise. As many of you probably understand the structure in the state of Florida, there are real estate brokers and there are real estate licensees. You can either be a sales associate or you can be a broker associate, but if you're acting in that capacity, you act underneath a broker. A lot of the rules surrounding FREC advertising, a lot of the point of FREC advertising rules is to make sure that to a consumer is aware of who they're dealing with. Because oftentimes you're dealing with an agent has their own type of marketing, they have their own type of branding that they like to do, but still the responsible party for them is their broker. So a lot of the rules kind of surround around making sure you disclose the name of the broker, the name of the licensee, the license information and things like that properly. The second element of FREC advertising rules is not to put false or misleading advertising out into the market, which is an issue even without the FREC rules. There's Florida laws, Florida statutes, common law that prevent against false advertising in any context, not just the real estate context. So it's covered under the Chapter 475 rules, but it also could be civil issues and things like that. So as a practical matter, any type of real estate advertising that you do, and when I talk about real estate advertising, I'm really talking about two different kind of concepts. One is you, real estate agent or real estate broker, are advertising your services to the public. Hi, I can sell your house. Hi, I can represent you, Mr. Buyer. Hi, I can help you do a comparative market analysis. whatever type of service that's licensed under Chapter 45, when you offer that service, you're advertising yourself as a real estate professional. The second kind of category is when you're actually advertising for a customer. So you're advertising a listing, you're advertising, you know, an open house, things like that. So these are the kind of two areas that I always see real estate agents partaking in advertising, either advertising their services to get clients or they're advertising houses to try to sell houses, which is the services they're rendering. Both of those constitute advertising and, in my opinion, fall under the rules of Chapter 475 and some of the other Florida statutes we're going to look at. At the most basic level, any advertising for real estate must include the agent's name as licensed on DBPR and the brokerage where their license is affiliated. So you might be tempted to just say, this is kind of my own business, I don't need to bring my broker involved. But under Chapter 475, they always want the consumer to know what supervising broker is in charge. And you have to give that information out in a way that a consumer can easily find your license. So you have to put your name as licensed and who your broker is, which is all publicly available information, but you've got to communicate it properly. Where I see agents go a little bit sideways on this and run into some trouble is they go by a nickname. You go by a nickname, but that's not your name in DBPR. You got to make sure when you're putting your advertisement out that your name as listed on the license is out there. If you do go by a nickname, then I suggest that you maybe register that nickname with DBPR in some fashion. You know, if you go by your middle name, put your first, middle, and last name on your DBPR license. That way someone can find you. If someone can find you easily, you're probably not going to have a frac issue. But if you're going by, you know, I don't know, some name that doesn't, the best real estate agent in the world, or, you know, something like that, some sort of tagline, and you don't put your name on it, then you're going to have an issue. Okay. So yeah, next. Actually, I'm going to pop down. I should have done this first. I did this in the wrong order. That's okay. Now let's talk a little bit about a team. If anyone operates as a real estate team is defined in Chapter 475 as, not Chapter 475, the FREC rules. The administrative code is up there in case you want to go read it. Is defined as any group of one or more that advertises under a name other than their actual name or their broker's name. So where people kind of get tripped up with this is because the statute says one or more, if you just advertise under a tagline or some sort of branding name, you technically fall under the rule, even though you're just one person. So if you advertise as, just looking at the group, if you advertise as the Alvarez group, then you need to follow the team names. If you just advertise as Juan Alvarez, then you wouldn't have to follow the team role names. So it's dependent on how you're advertising yourself out to the public. But if you're operating as a team, there's actually more than one of you, and you use some type of group name to categorize all of you, then you're going to trigger the team rules under the FREC rules. So just to go over quickly what you can use and what you can't use for team names. You can use the word team. You can use the word group. You can't use agency, associate, brokerage, broker, company, corporation, corp, Inc., LLC, LP, properties, property, real estate, or similar words. The distinction between these two categories, what name you can use and what name you can't use, is that it has to be clear that you are a team operating under a brokerage versus a standalone brokerage. So just a little note here, this is a little bit different than if you are a PA or a LLC. If you operate your licensed individually as a PA or LLC, then you can include that PA and LLC on your license name. But your group should not have PA, LLC, or have any other type of designation or name in the entity or in the group name that implies you are an entity. The second part of the team rule name, besides what you can call yourself, is that in any advertisement in which you're advertising as a team, you also have to advertise the brokerage that that team is a part of. So, and you have to do that in a way that the font size is the same, the logo size is the same, things like that. So that way it's clear who the brokerage is. So if you have, your logo you used to have an example. If you have your logo this big on the website, and then the brokerage information is at the bottom and it's this big, that's not going to work, because a consumer, when they look at it, could still imply that is its standalone brokerage when really it's part of the team. So if you have your logo here, you've got to have the broker logo right next to it. And you can get creative in how you've done that. I've worked with clients, individual agents, and small groups who do, they like to use the word powered by. So it's the Smith Group powered by brokerage. Stuff like that. You can come up with ways to do this to make it not so burdensome, but you still got to make sure that you have the brokerage information out there, and that if you're advertising a logo, that you have the broker's logo out there as well. Okay, so now that we've gotten through names, team names, the basics, and just so also as an aside, any advertisement that goes out there, the minimum information that you need to have on an advertisement is your name and your brokerage. Everything else is really what you need. You should have your phone number because you want people to call you and ask for your services and contact information. But what you have to have is your name and your brokerage, because it's all, I shouldn't say all that FREC cares about, but what FREC cares about very importantly is, does the consumer know where you work and who you are? Okay, so now that we've got the FREC basics aside, let's talk about false advertising. So the actual rule that comes out of FREC says no real estate advertisement placed or caused to be placed by a licensee shall be fraudulent, false, deceptive, or misleading. So that is an actual code that falls under FREC that is actually something subject to your licensing. So if you do some sort of fraudulent, false, deceptive, or misleading advertisement, you could have licensing issues. However, you could also have civil liability to anybody that is harmed by such false advertising in a civil action. There is a lot of common law on false advertising, on misrepresentation and things of that sort, but there's also statutes. And those statutes are generally consumer protection statutes, and there's elements of fraudulent advertising that fall under those statutes. Those statutes come with prevailing parties fees and certain types of damages and things of that sort. So you really want to stay clear of what any false or deceptive advertising in both how you market your services and how you market houses. So let's talk about free. So my background, I know we have one person from my old life on this call in timeshare. I used to work in timeshare, and timeshare had very, very strict advertising rules. So I kind of learned the advertising rules back in my timeshare days, which was a good place to start because they're very heavily regulated. But one of the biggest things I used to have issues with when I was doing marketing reviews as a paralegal in the timeshare world was that all the marketing folks always wanted to use the word free. This is free, this is free, this is free, this is free. Nothing in life is free. There's just nothing in life that's free. So the rules around free is that anytime you offer something for free, if you use the word free or something similar to it, like no charge, or you can't just change the word. If you're implying that there's no charge, the condition that you have to, or the condition that has to be met for you to give whatever it is you're giving away, has to be right next to the word free. So if you have this, I will give a free KitchenAid to any buyer who buys a home with me at closing. But really, you're only going to give a KitchenAid if you earn at least a $10,000 commission. Then that little condition needs to be right next to the word free. So I put that out there. I know we use the word free generally. When we were working on the advertising this week for Get Closed, Get Paid, I caught myself writing free. And then I was like, oh, is it free? Is Get Closed, Get Paid free? Yes, we provide this without any form of payment. However, Erin and I are advertising our services as we do this meeting for you all. So is it free? No, there's always some sort of reason why we do these things. So be very careful if you're ever advertising something for free. To avoid fraudulent, false, deceptive, and misleading advertising claims, the most important thing you can always do is be clear about what you're advertising and make sure that you can honor it. If you want to advertise to buyers that you advertise to sellers that you'll take X amount of commission on a transaction, or you'll rebate closing costs of X amount, make sure you know exactly what terms that you want those types of offers to come with, and then make sure those are advertised in any communication that you do. Switching the script when we're working on advertising property, this gets really challenging because it triggers a whole nother area of the law, which is sellers disclosures of known defects in properties, and things of that sort. Make sure when you're advertising a property, you're advertising it right. If you advertise a home as having a brand new roof and the roof was put on 6 months ago, it's not brand new. So this is where, if it was up to me and I was drafting your marketing content, you would never sell a house, because it would be, the house was put in, or the roof was put in 45 days ago. It would be so boring, nobody would ever sell. But you, as the marketing guru, really has to, I always say, write it out, write your marketing content, whether you're writing your little blurb for social media on a new listing, or you're writing your MLS remarks, whatever you're doing, you're writing a flyer for an open house, write it out one day, and either later that day or the next day, do a pass through for anything that might be misrepresented. Something that you can clear up, and make sure you get it properly signed, and maybe have the seller sign off on it. Like, hey, look at this. Are you sure the AC is new? Are you sure the AC was installed within 1 year? Is that backed up on a seller's disclosure? Have you shown me that? Have I seen a permit? Do I know I'm saying this properly? So do your diligence and make sure you're advertising right. If you falsely advertise a property, you could cause issues both for you and for your seller, because of the way the disclosure rules read. So always make sure you've got your facts straight when you're advertising. And like I said, I know you don't want to draft it like I would draft it, because that's not going to sell a house, and that's not going to be effective for anyone. But just try to do it in a way that you're being as clear as possible to the consumer. It's also prevents surprises. Yeah.
Kristen, if you wrote an ad for a house, I would buy it, because I would know exactly what I'm purchasing, by the way. I do have a little cautionary tale, especially when we're talking about writing up marketing materials for advertising. If you're using artificial intelligence, make sure what AI spits out actually accurately reflects the condition of the property. I've seen some beautiful language in marketing materials and listings, and it does not reflect the actual condition of the property. They use beautiful adjectives, but it is not an accurate representation of the property. So if I'm reading the words, it's not matching up with the pictures, not really effective advertising, but also it could be deceptive. And let's rewind for a second about the word free. Is there another instance where agents may be accused of using the word free in their advertising and their services that have gotten them into hot water recently?
Yes. So for anyone following the antitrust lawsuits, which Erin and I have been training on quite a bit at the Board of Realtors, and we're going to be doing some trainings this year on that as well. One of the big issues that has been brought by the class plaintiffs is that buyer's representation has always been advertised as a free service. And that's inaccurate, because the buyer's agent is being paid, they are being compensated, and that's ultimately impacting the purchase price. So while the buyer might not be physically writing a check to their buyer's agent, they're paying for their compensation in some form from the price of the home, and the sellers need to, the seller is paying the compensation and things like that. So if you are still advertising in any way buyer services as free, that's inaccurate. And policies are starting to back away from that. Guidance is starting to back away from that, which is accurate. If you're representing a buyer, you need to be clear that you are compensated. Well, number one, you should be using buyer broker agreements, which we've taught on before, and we're going to teach it again this year. But your compensation is based on form contract that you have with your buyers, and how much you charge. And then there can always be a conversation that if a seller wants to offer compensation, you can offset that amount, but this is what I charge. That way it's clear how much compensation you're receiving on a commission, on a real estate, how much real estate compensation commission you're receiving on a transaction. That's where you wanted me to go, right?
Thank you. Thanks for going there. Yep.
Okay. All right. So social media. There's a specific rule on website and social media, which is so exciting. It's back when I did timeshare registrations, I had the task of doing coming up with disclosures for Twitter before there were rules on how to disclose things on Twitter. And back when you couldn't like attach a photo, you just had to like somehow hyperlink in that little character count 4 pages of conditions to a text. And it was always very hard to figure out. And it was back when Groupon was just coming out, and you were always trying to figure out how to get your disclosures into the rules. Now we actually have social media rules, which makes this so much easier. So Florida Real Estate Commission has an actual rule on websites and social media, which is great because then you know exactly what you're supposed to do. So whether you have a website or a social media page, and I say that because a social media page, like a Facebook page that you use for your whether you use it for personal and business or business, it's usually a representation of your business. So I would treat it like a website. So if you have your logo in your picture or on your cover sheet on Facebook or what is that called? Cover picture. You need to make sure those logos and stuff that follow the advertising rules. So specifically the rule on websites, social media is when advertising on the internet, the brokerage firm name as required in subsection 1, which is the rule we went over first, shall be placed adjacent to or immediately above or below the point of contact information. Point of contact refers to any means by which the contact, brokerage firm, or licensee, including mailing address, physical address, email address, telephone number, or fax. I also like to interpret this as a contact us button, either through a direct message on social media or contact us type of link on your website where you can capture lead information. Anywhere where you can capture lead information or there's potential for contact, you need to make sure you disclose the 2 most important things to FREC, which is who's the real estate agent at making this advertisement and who do they work for, who's their broker. So it's easy. Now you know, this can be a little challenging. You got to get creative. On Instagram, you got to maybe do a link tree or do your little handle, work with your logo, but I work with a lot of agents and we get creative and we try to make it to where we exercise creativity with the consumer in mind. That's kind of how I say it. We try to make sure we can make your marketing as beautiful as possible while also making it clear to consumers. Okay. So illustration purposes, we're going to talk about a pen. So I use specifically, I don't know if I can get this in the screen. So my law firm mug, okay, which has coffee all over it. As an example, anyone who likes to brand and advertise, which you're going to learn about next month from Crystal, which is going to be so fun, but you learn that you kind of always live in your brand. I know a real estate agent that I love very much whose branding is purple, and you will see her in purple every time you see her. And that's recognition, and that's not my wheelhouse. That's what you're going to learn from the expert next month. But that type of recognition of your name and the services you provide is not always necessarily marketing, but it is kind of marketing. You're not maybe advertising a specific service. You're not advertising a house. You're not advertising an open house. You're not advertising that you'll provide legal services, but you're getting people to remember who you are and what you do in case they ever need their services. And in connection with that, people who are great at branding tend to have all kinds of swag. Hats. I've worked on hats. I've worked on pens. I've worked on mugs. I've worked on all kinds of things. I've had agents that market at pools in their community, and they hand out water and they hand out sunscreen with their name on it. You can get so creative in this. It's a question of whether you're advertising real estate services. So the discussion of a pen, if you just put your name on the pen, do you have to put your broker's name on the pen? If you just put your website link or your URL, do you have to put your license name on the pen? These are questions that I get all the time. And we try to go through the analysis like this. Well, are you going to have the pen on a table with your business cards that has all the information? Then we could probably put whatever you want on the pen because it's going in connection with the business cards that has all the applicable information. Or maybe you're not even handing out the pen. Maybe that's just a pen you bring to closings and hand out to your customers who are already engaged. There's ways, it depends on how you use it, and it depends on what information you're putting out there and what you're putting it with. So my favorite example is a hat. I had a team want hats, and we couldn't figure out how to get the broker's name on the hat without it looking just absurd. I mean, the hat looked silly. And finally, we got to the conclusion of, is the hat an advertising piece or is it a branding piece? Are you going to be offering services through the hat? And the answer was no. The person just wanted a hat to wear to their kids' baseball game so people knew that he was an agent and he did real estate. There was never an offer of services and things like that. And I said, you know what? We're just going to put the logo on the hat. If you ever engage in some type of advertising in connection, someone says, hey, I see your hat. What do you do? Make sure you hand them a business card that has all the proper information on there. So there's no clear answer of how you do marketing swag, but I will say if you're going around a pool, handing out water, handing out sunscreen and saying, hey, I'm a real estate agent, I can help you with any of your real estate needs, make sure your name and broker information is on there and your contact information. The most important thing I always say about this is you want people to know your name. Whatever you hand out, you want them to know your name and your phone number because you want them to call you. So if you're giving them your name and your phone number, you got to add that broker's name, work it in somehow to comply with the FREC rules, and then you're in compliance. Okay, so before we get into other considerations, 2 areas that are a little more complicated that would be beyond the scope of this class, because it would probably take its own hour, is text messaging, email marketing, and text message and email marketing. So and cold calling. So text messaging, cold calling is subject to do not call laws. Text messaging is subject to the TCPA. And both of those there's federal laws and there's state laws applicable to those types of activities. They're very heavily regulated. What I usually recommend is that if you want to do some sort of cold calling, make sure you're verifying your list against the do not call list. If you're doing some sort of text message marketing, there's certain things like opt-outs, there's certain things like double authorization, how the phone numbers are submitted, where you're getting the phone number submitted from, is there authorization to text? All that comes into play. So if you're utilizing a service for text message marketing, make sure they follow those certain types of rules and make sure that they put that in their contract, that their services are compliant with federal marketing laws, state and federal marketing laws. That's probably the easiest way to do this, is hire a proper marketing or some type of service that does this the right way. Same thing for email marketing. If you do email, if you use like a constant contact, I don't know if people still use that, MailChimp, things like that, make sure that they follow the CAN-SPAM Act, which has certain opt-out features and things like that. So all of those are all federal complex laws that has lots of nuance, but the most important thing you can do is hire a reputable company that's going to follow those for you. That way you can just work on your marketing content and they take care of the opt-out and things like that. If anyone ever opts out of your marketing materials, you need to take them off of your list. That is how that rule works. Unless there is one exception. They have an existing business relationship with you. So if a seller opts out of your marketing materials, that's fine. You can take them off of your marketing list, but you still have an active listing with them. You're still allowed to email them. I've gotten that question before. You can still email them about their transaction. You just can't advertise your services. So that's it. That's my quick and skinny on advertising. Like I said, next month is going to be Crystal to teach branding. And she actually is focused on real estate agents. So she knows how to do the teams and the logos and the names and make sure you're doing it all in a proper way. All right, Erin, you got a question for me?
We have a question in the chat. So Melissa asked, hello, how about a for sale sign? Does that need the broker or sales associate's name?
That's a great question. So for a for sale sign, I recommend having the company name, and then I typically see the broker's name. There used to be, and he's a dear friend of mine, so there used to be someone in my neighborhood that used to advertise in it, and his sign I thought was not in compliance, but I didn't know how to tell him. But I used to walk my neighborhood and show it as an example. Anytime someone called me, I would walk down to the sign because he's always got something to tell on my street. But that one, it was always, that sign to me always read as the agent and never showed the brokerage. And I don't think that's right. I would always put the broker's name and the agent's name in your for sale sign. And of course, your contact information.
when you're saying broker, are you saying brokerage as in the company name or the managing broker human being who's in charge of that brokerage?
Nope, the brokerage. So if you are a licensee and your license is affiliated with a corporate broker, then put the corporate broker information on. And that's always what has to be on your advertising. So on your website, you don't have to put your broker's name, you have to put your brokerage. It's which corporate entity is responsible for you. Now, if you're operating as a broker, the rules are a little different. If you're operating as a broker, then you need to make sure, like your actual company website, then you're going to need to put the broker's name somewhere on that website and the address of where you work, all that kind of stuff needs to be out on the website. If you're an agent, then you need to have your contact information and where you work.
Oh, got a couple more questions. So question from Sarah, is an email address considered marketing? So for example, if an agent has their name like Joe Smith Realty at gmail.com, is that okay? Or is that deceptive since he's not his own company? Or Joe Broker at gmail.com, maybe he's a broker associate, but he's not a broker of his own company. So the email address itself at a Gmail, for example.
Yeah, so I just realized I didn't include that. I have this in a different team specific slide. So when the rule first came out, which I want to say was probably 4 years ago, I could be wrong on that. There was a little bit of time where they were honoring domains created before the team rules went into place. But team rules, social media handles are still considered, they still have to comply with the team rules. So if you had that before kind of team rules went into place, there was a little bit of honoring those changes because you couldn't change your whole email system. But generally, if you're starting out now and you're starting a team, you want your name. You don't want to imply a company in your team name because that domain could be subject to a team rule, the team rules. The other thing I just want to note is that if you are operating as a realtor is a protected term that's owned by the Florida National Association of Realtors, and it comes with branding guidelines, which I believe you can find on the National Association of Website or Realtors page. But how you use the term realtor is dictated by various terms. So you generally can't have realtor because it's not, you don't own that word in a domain and things like that. So, I mean, I don't know that it's policed or how that works, but there is restrictions on how you can use the word realtor.
Okay, and what if you are operating as a broker associate and you're not the broker of your brokerage? Can your advertising say that you are so-and-so broker, Joe Broker at gmail.com, or do you need to specify broker associate since you're not the managing broker of the company?
This is a great question. This also comes up with sales associates. I see sales associates call themselves very fun things. Like you guys come up with some great names for yourselves, but sometimes there is an implication that you run the company and that can be problematic. I've seen all kinds of names. Executive sales associate, things like that. But if you are not the qualifying broker, then you should not represent yourself as the broker. You can represent yourself as a broker associate. You can represent yourself as all of, the various credentials that you may have, whatever that may be, but always make sure that you imply that you work for a brokerage company and who that company is.
I just put in the logo and trademark rules from NAR into the chat if anyone wants to pop in and see those. And thank you. So, yeah. And then also, do you have any resources, Kristen, on the do not text rules, like the do not call list for national and state? And if yes, can we provide those by email to the attendees after?
I can. I actually did a article on this, but it was in a magazine. So I don't know if I can share that, but I will find something that I can share. But yeah, the text message rules, I mean, they're a little complicated. Your best bet is there, I think, is to find a vendor that does it right. But at least you'll know what the rules are and you can ask the right questions when you're interviewing with a vendor.
Yeah.
All right.
And what we didn't talk about today was co-marketing and marketing services agreements and working with your preferred partners in creating advertising. We can do a whole presentation on RESPA and that kind of thing. But just be aware there are additional rules if you plan on doing marketing with a with a business partner, make sure that what you're paying for, you are getting, and also that you are paying for your fair share of the advertising. So, and consult counsel if you have any questions.
Yeah, that's a good one. We should probably do that, like how you can sponsor we could do a whole class on how you are and are not allowed under RESPA to have joint marketing with RESPA covered entities like title, like mortgage, things like that, and what they can do in an open house, what they can't do. That's a good topic. Maybe we should add that.
Yeah, I love it. Awesome. Are there any other questions in the chat? I don't see any. So as we mentioned at the beginning, all of our presentations will be available on YouTube. Kristen, you're getting becoming expert level of popping them up onto the YouTube after the presentation. So, but if you have any other topics you'd like for us to present, please send us an email, info@getclosedgetpaid.com, or you can find us on social media under both of our names, or at Get Closed Get Paid on Instagram, getclosed.getpaid on Instagram. If you have any questions, please reach out to us. Otherwise, we'll follow up with a recap email. And Kristen, you want to show the last slide with our next presentations? So we do have our schedule for the next 6 months. So next month, we're talking about branding for real estate agents. We have a special guest, Crystal, who's going to share everything marketing related that is not boring legalese. And in March, we're going to talk about personal property pitfalls. I know we want to focus on real estate, but sometimes that pesky personal property ends up in our transactions. And we want to talk about ways to make sure that our transactions can still move forward, even if there is financing, even if the parties are in love with the table and chairs. Also, April 9th, we're going to do a buyer broker mastermind. Hopefully we'll have some news to provide updates on both the NAR lawsuits, the national landscape, and also here in Florida. And we'll recap how folks have been doing using the buyer broker agreements that we've been talking about for the past few months. On May 14th, we'll do a legislative session recap and a legal update. And June 11th, we'll talk about condo and HOA disclosures. And then one thing we haven't yet mentioned, we are going to start doing legal updates and attorney questions and answers. That'll be Thursdays on the same week that we do our Get Closed Get Paid presentation. So it'll be Thursdays, second week of the month. And we'll send out a link for everyone who's attended our presentations. If you guys want to share the link, we will have sort of an open discussion. We're not going to record it unless you want us to record your questions. But we just want to make sure that we have an open forum for folks to ask questions that are not necessarily on a specific topic that we want to talk about. But keep in mind that we're doing Get Closed, meaning contract issues, closing issues, and get paid. We want to make sure that you are able to be compensated for your transactions and your hard work, especially as we go into 2024. So thank you again for joining us on Get Closed Get Paid. We'll see you next month.
Thank you, guys.
Thank you.